Compliance and Amendments Committee of the Sunshine Ordinance Task Force, called to order at 4:03 on May 15th, 2012. Ms. Osprey, would you call the roll, please?
Member Nee.
Here.
Chair Washburn.
Here.
Member West. Absent. Vice Chair Wolf.
Here.
Johnson. Member Johnson. Absent. We have a quorum.
Thank you. I didn't realize Member West was a member of this.
He's not.
He's not a member.
I'm sorry. I'm sorry. It's my fault. I haven't written on my call sheet.
Okay. All right. Thank you. It would have been Member Snyder.
Member Snyder.
Yeah. Okay. There's one change to the agenda that I'm currently aware of, and that is item number 7, file number 11058. This is a continued hearing on an order of determination of Nick Pasquarello versus the Film Commission. And Mr. Pasquarello has requested that this be withdrawn. Is there anything we need to do? No? Okay. All right. That's all that I'm aware of. Ms. Osprey, would you call the next item on the agenda, please?
Item number 2, adoption of the February 21st, 2012 special meeting minutes.
Move to approve. Second.
I reviewed these minutes actually several times, and I just have on page 3, item number 5, next steps on Ethics Commission proposed policy for handling sunshine-related complaints. I had noticed a problem with the first sentence that Chair Washburn provided an overview of the proposed policy for handling sunshine-related complaints, and that isn't what I did. I have some wording here that I'll pass on to you, Ms. Osprey, but it should read something to the effect of Chair Washburn introduced the item with a review of the activities and hearings held by the Compliance and Amendments Committee to address the Ethics Commission's proposed policy. So I just went back over the couple of year and a half's events regarding this. So and then the other, I would suggest that you put a hyphen between sunshine and related. And that's all I have, members. Okay. Is there any public comment on these minutes? Okay, seeing none. Ms. Osbury, would you call the roll, please?
Member Nee.
Aye.
Member Wolf.
Aye.
Chair Washburn.
Aye.
There are 3 ayes.
Ms. Osbury, would you call the next item on the agenda?
Okay. Item number 3, adoption of the March 20th, 2012 regular meeting minutes.
Move to approve. Second.
Member Nee?
Yeah, I have a number of suggested edits. None of them would really change the substance of the minutes. So, there's nothing factually erroneous in there. So, I've printed them out, and I will hand them to our clerk. But to me, the minutes are, including the suggested amendments, I would say the minutes are acceptable.
Member Wolf? The only thing I saw in reading over these was item number 8 on page 4 of the amendments, or of the minutes, rather, under speakers for public comment. I wasn't sure about the first sentence. Jason Garza spoke expressing concern with his open complaints and order claims are heard. I guess you meant to say the order in which the claims are heard. That was just a wording. I don't know if Member Nee caught that.
Nope.
Okay, but I'll give you the recommended wording. At this time, is there any public comment on the minutes? Seeing none, Ms. Osprey, would you call the roll, please?
Member Nee?
Aye.
Member Wolf?
Aye.
Chair Washburn?
Aye.
There are 3 ayes.
Ms. Osprey, would you call the next item on the agenda?
Item number 4, adoption of the March 29, 2012 special meeting minutes.
Move.
Second.
Member Nee?
Yes, again, there are some suggested edits, but nothing that would really change the substance. So I think, good job, and they're acceptable with the edits.
Member Wolf, you have anything? I have nothing. Members of the public?
Other than that, it was on my birthday.
Oh, right, that's why you weren't here.
No, I'm not here for other reasons, but
Everybody take note of the date. Okay. At this time, is there any public comment on the minutes from the special meeting? Okay, seeing none, Ms. Osprey, would you call the roll, please?
Member Nee?
Aye.
Member Wolf?
aye.
Chair Washburn?
Aye.
There are 3 ayes.
Ms. Osprey, would you call item number 5, please?
Item number 5, adoption of the April 17, 2012 regular meeting minutes.
So moved.
Second.
Any comments here?
No.
Okay. Aren't there any comments from the public on the minutes from April 17th? Seeing none, Ms. Osprey, would you call the roll, please?
Member Nee?
Aye.
Member Wolf?
Aye.
Chair Washburn?
Aye.
There are 3 ayes.
I'd like to congratulate us on getting all these minutes approved. They were really very good. Thank you. Ms. Osprey, would you call the next item on the agenda?
Item number 6, proposed Sunshine Ordinance Amendment regarding electronic document backup, storage, and retrieval.
Member Nee, would you like to introduce this to us?
Yeah, well, this was drafted last June, I believe, by members Wolf and Costa, and I think it's fairly thorough. There are some minor edits that I saw, and I really didn't have a chance to do it as I would have liked. The only other thing that I would say is we need to figure out where in the ordinance this would appear, which section.
Madam Chair.
Member Wolf.
I was under the impression we created a placeholder for it in the, when we were doing the numbering and the ordering, the construction. I think because at the time that we didn't have the language for it, we at least included a section. I don't have the full amendments with me. Are they in the packet?
You mean the full amended minute?
Yeah,
amended
I don't
ordinance?
have that with me, but I'm pretty sure that we created a placeholder.
Where would it make sense to put it?
It's kind of got to be its own thing, except, well, there's a section that discusses retention. It's really about retention. Let me see if I can.
Member Nee?
Yeah, possibly Member Wolf is referring to section 67.29-7, correspondence and records shall be maintained. Other than outside of that, the only other place we might want to do it is policy regarding 6721-1, which is policy regarding use and purchase of computer systems.
What about adding 67.298? Would it warrant its own?
I would
Separate.
have no problem with that.
I think it's a discrete enough and big enough item that it warrants its own.
Well, or
Place.
67.297D, D for Delta.
What is it? Excuse me. What is it?
67.297D, as in
Seven.
David.
Yeah, that's satisfactory to me. Yeah.
Oh, okay.
Yeah, that's the section I was referring to. It's, yeah, I think adding it as D would be good. I don't think that it makes anything redundant too much. I think it expands on A. Just don't want to have two paragraphs at the same level that might be in conflict with each other. I'm wondering if this should not be A and all the other ones move down, because this is the overarching description of retention.
But doesn't this pertain specifically to electronic documents, whereas A talks about not just electronic documents, but all documents?
This is electronic documents. Well, it is all documents because, it says it in A, all city entities shall have means to store, backup, restore all electronic documents their staff produce, receive, or reproduce electronically, either organically, electronically scanned, or by other medium process. It doesn't describe like somebody scratching notes on their desk or a calendar or something that may not be in the system or something like that. The purpose of this was so that anything that was turned into electronic document or created as electronic document would be maintained, and that there would be backup storage, the ability for it to be searched, so on and so forth, as opposed to something handwritten that
Right.
wasn't scanned in for some reason.
Right, but right now, A reads it's inclusive of everything, and it could be paper documents or scratches on a appointment book.
As long as it was reproduced electronically.
No, I'm talking about what's
Oh,
6721-7A.
The current A.
Yeah,
I
the
see.
current A is
Yes.
all-inclusive.
Yes.
And then it seems to me the current B and C are specific classes of documents, which could be paper or electronic. And
Okay.
then it almost makes sense to have this be 6721-7B.
Okay. I'm okay with that. I just wanted to make sure that that I wasn't overlooking something that by putting it at the same level, like maybe it should be A1, but I don't know whether, follow what I'm saying? I don't know whether it's overarching or whether it's specific. I just want to make sure that we don't get into some sort of a struggle that later on down the line when you have a hearing that comes up and somebody is trying to find a violation, that they could say, well, this other paragraph in the same section is in conflict,
Right.
and that kind of thing. So I just wanted to make sure that we have, that discussion, if there is any discussion about it.
So possibly 6729-7 B.
Yeah, B, and then the A, B, C, and Ds on the amendment would be turned into, how are they? Are they Roman numerals or are they actual numbers?
They're actual numbers.
Or, no, they're
Oh.
lowercase Roman numeral. So it's the letter I. A would be I, B would be I, C would be I.
I don't think so. I don't think so. If you look at
Oh,
6724.
you're right.
Yeah.
You're right. You're right. It is numbers. You're
Right, numbers.
Yeah, I'm looking at the.
But the one that's here would become I have a question. Should we, I always tell students when they're doing outlines for me that if you have a 1, you have to have at least a 2. So we just have a 1 there. Doesn't make sense to me.
No. You have, this would be B.
No, I understand. I'm looking at, sorry, I'm getting off track.
Okay.
But, no, what I meant to say is, looking at it now the way it is, forget putting it in the document. We have A, B, and then B1, but we don't have a B2.
Yeah, on the amendment, these A, B, C, D would be turned into 1, 2, 3, 4.
No, I understand that.
Look at the text as is.
As it is, yeah.
As it is.
Yeah.
And under B, you have 1. You have a subparagraph 1 there. And since there is no subparagraph 2, the 1 becomes superfluous.
Yeah.
That's what we're saying.
It should be,
So if that was, if that
Oh.
became 1A, then the A would become superfluous.
Oh, I see. And you're talking about on this?
Yeah.
Oh, and B here.
just
Okay.
looking at that, yeah.
Got it. So would it just be subsumed in B?
I think so.
In the main text of B?
That's what I would recommend.
Okay, and then in the future, if it needed to be amended, it could be separated out? Is that the idea?
Well, but if you separated it out, you'd have to have a 2, too.
That's what I'm saying. If
Oh, yeah.
there was a need to add a 2,
Oh, yeah.
technology changes, that kind of thing.
Right. I also have a question. Shows my ignorance about these things, but what does it mean to reproduce electronically, either organically, electronically scanned, or by other medium process? What does organically mean in this context?
Either one of us could answer that. So reproducing electronically is if something is already electronic, and then you print it out. Or you take something that is hard copy and you scan it in. You're reproducing the document in a different format. So here the format is electronically.
What does organically mean, though?
That it doesn't exist anywhere else. So you can take a copy of something and then reproduce it and have another copy. But it's not the original. It's not the original organic copy. Or not copy, document, the organic
Couldn't
document.
we say original document?
I don't remember why Jay and member Costa and I had decided to use that word. I think we wanted to make it as pure as possible. Original, I guess original would be the same. Either
I
way.
doubt very seriously if many people would know what that meant, organically.
Well, it's something that's used in the IT world.
Well, but this is
kind
meant
of a-
for people who aren't IT people.
Well, yes and no. You want to be specific about what it means. An original might not mean in an electronic format. You know, originals may not be the actual original. Well, you can make a clone and it would be exact. How you determine the difference. See, that's where organic comes in. So that's the reason why we decided to use organic. It's just the way the electronic documents work.
So I can see with electronic documents, it would be, if you have a lot of the same documents around, you'd be hard pressed to find the original one.
Unless you, right,
Well, unless you found the one that was created first by a
Right.
timestamp.
right. Well, it's not just timestamp, because you can clone that too. So, I mean, everything is more or less hackable. It's the information that's on it. So you want where the organic, where it originally came from, excuse me. So it's just the way we term things in the IT world. I can't explain it any other way.
Member Nee?
Well,
But I'm okay with changing it. I mean, if you want to make it original,
I think we need to find a way to put it in lay terms. You know, it's fine if if our intended audience here was the IT, you know, the IT community. But remember, this is something we want to put on the ballot, and we have to be able to explain to the average voter what we're talking about. So, you know, while I certainly respect what you know what's been put down here, you know, in terms of the purpose of it, when it gets out there to the voters, you know, the easier we can make it for them to understand, the better.
Member Wolf?
I'm not going to argue the point too much longer. I just wanted to say that legally, if there's a difference in the meaning between organic and original, we're talking about putting this into law. And so you want to make sure that you have the correct terms with regards to the context. So that's the only reason why I'm kind of speaking out on that point, because of the context that it's in. No matter whether the public understands what it means or not, what's important about that is whether the people that have to obey it first are clear on what the guidelines are. And so, I mean, maybe we could add the word original.
Mm-hmm.
You could add it and leave the word organically in there.
Member Nee?
Let me ask you, instead of organically or organic, would the phrase already resident within the city's or department's system, would that be an adequate and clear explanation of what organic means?
No, think of it as the original, like I write something down on a piece of paper.
Mm-hmm.
That is not, you cannot clone that. People try to forge signatures and things like that. We're talking about the original signature. That's organic.
Okay.
Okay. If it was somebody was able to forge a signature, then that would not be organic, but it could be claimed as being original.
The original forgery.
Right.
I like that.
So that's the thing is to make sure that we cover all the bases so that when legal counsel needs to make advice or something, that there's not some twist somewhere that creates a loophole for somebody to squeeze out of. That it's just trying to cover all the cracks. Because we know technology is going to change, and there's going to be new formats, there's going to be new processes, and it's going to have to be amended at some point. I'm wondering if there should not be something. I don't know if it's possible to create something where the task force has the ability to fill in those cracks as they arise, so this doesn't have to constantly go back to the voters on matters that are technical. But it doesn't change the meaning of the intent. It doesn't change the intent. And we tried to make this as broad as possible so it covers that. But I don't know if, the changes of backups may exist in some kind of different way in the next 3 years.
I guess the main principle here is that the intent be clear to those who drafted this in the first place, and be able to be conveyed to the public who's going to vote on this, and be clear to government agents, the agencies and departments that have to abide by this, and then also by the task force. That's, yeah.
Yeah, I mean, I'm okay the way it is. Okay, if we want to add the word originally or something like that, it's fine. But I'm okay with the way it reads for today. Okay, I'm just bringing up a concern that in the future, as technology changes, and I may not know what that is, somebody releases something and it's a completely different thing than
Right.
the intent of this. I just want to make sure that if there's any way for the task force to be able to fill in that crack or that loophole without constantly having to go back to the voters on these technical issues. I think we've covered as much as we could, store, backup, and restore. I mean, that's pretty much the intent of the item. So,
Well, I would think if the intent is clear and specific enough, but
okay.
then the interpretation of individual cases that come forth could follow even with changes in technology.
Okay. I mean,
I mean,
we tried to take that as much
Okay.
into account as possible when we did it. And throughout all, the couple of years that it's been kind of floating around, we've been talking to other people. We check our own, IT communities about, this is as kind of broad as possible, comprehensive, so we can make it.
okay. Member Nee?
Yeah, I have some suggested edits in here. Briefly, in paragraph A, which would become paragraph 1, backup, in this case, is a verb, so it should be separate. 2 words. Also,
Which ones? I'm sorry, say it again.
in the top, paragraph A,
Yeah.
line 1. Okay, backup is a verb here, so it should be 2 words. Backup is not a single, a backup copy, backup as a noun or as an adjective is 1 word. But
Gotcha.
to back up, that's 2 words. In paragraph 2, the way the sentence is written says all public information shall make available. You have public information there is the subject in that sentence, the way the sentence is structured. And public information is shall make available is, I don't think, quite the way we want to say it. Also, so I would say shall be made available would make a bit more grammatic sense there. But I have another question or observation on that, and that is, why are we talking to all public information in the custody of a custodian of records? What if it's not in the custodian's custody or control? Why do we want to have that phrase in the custody of a custodian of records?
I think the focus of that was in relation to 6721 when we were drafting this.
Mm-hmm.
So 6721 is primarily focused on the custodian of records and the production of those records based upon a request. So that may have been an oversight to limit it to custodian of records, and maybe it should be expanded.
If we
Custody of all public information in the custody of the city and county of San Francisco. Okay.
or any entity therein.
Okay.
And then again, shall be made available, CCSF, or any entity. Madam Chair.
Member Nee?
Yes, to continue, in paragraph C, which would become paragraph 3, Again, these are suggested edits just from the standpoint of making the sentence more readable. I would knock out, let's see, it says upon request by a requester. I would say upon request by a member of the public, either a member of the public, or the Sunshine Ordinance Task Force, comma, any and all public information where the information, yeah, other than that, it's fine. Because you have, yeah, just a member of the public, then you're making it a bit more readable.
Okay.
Other than that, I'm good with it. You know, a tip of the cap to members Wolf and Costa on this. They've done it's brief, but I think they've done an excellent job.
Madam Chair, just one last thing.
Boyle?
On Member Nee's edit in B, City and County of San Francisco or any entity within, would that be,
Therein.
oh, therein?
Mm-hmm.
Okay. And that would be inclusive of all entities that must abide by the Sunshine Ordinance? Is that the intent?
Yes. Are there any entities that are not, any entities within the city that are not under the ordinance's jurisdiction? I don't think
know.
there are.
Okay, I don't know.
Well,
I'm
but
just asking.
we could say any entity therein to which this ordinance applies. We could say that, but
Isn't that assumed throughout the ordinance, though?
Well, I'm just looking at the issues around like 12L, you know, which are not part of 67, but there's still some.
well, but 12L is for nonprofits. They are not part of the city. They are not entities of the city.
But they must abide by certain rules of the city,
That's true.
and then have to, you know, are compelled to abide by those rules that could normally apply to something else. But I'm just wondering if there are any entities that are like that would, like a contractor. Would a contractor come under the Sunshine Ordinance for monies that it receives, like what happened with the Earthlink Google Wi-Fi situation?
There are some contractors that agree in their contract to abide by the Sunshine Ordinance.
There's no requirement? I thought it was a requirement. I have to sit and look it up. I'm sure Member Mr. Pilpel will be able to.
I don't think that certainly, I don't think every nonprofit takes that.
No, we're just talking about what other entities that
Yeah.
are not necessarily under the city, but must assume obedience to the Sunshine Ordinance because it receives city funding, and that it must reveal the finances or how the expenditures or what have you, abide by work and labor relations, things like that.
Well, okay, what we could say then is City and County of San Francisco, comma, any entity therein, or any outside entity to which this ordinance applies, or to which this ordinance is deemed applicable.
Yeah, something like that. That would be good for me.
Mr. Pilpel, do you have anything do you have any comments on this?
Okay. Can you hear me now?
Yep.
So just to address that point, I'll hold my public comment until later. If the intent is to only apply to city and county agencies, then I would limit it in the way that is suggested in the preamble. Chapter 67 covers
Okay.
city departments, broadly speaking. 12L covers nonprofits, but does not cover nonprofits in the same manner. I think it would be a reach to get at more of nonprofit records through 12L or through this amendment. I think that would be difficult.
I think it would be politically suicidal, probably.
Well, I'm being diplomatic, but
I'm looking at 6724, which is a pretty extensive listing of documents or information that would be public.
that, if I might, I think those are documents that are subject to immediate disclosure. There are other sections of the ordinance that govern solicitation of funds and other kinds of records that need to be disclosed. I mean, I can get into that more, but if your point is to try to capture electronic records that are held by a city department, I would probably try to accomplish that. To go farther gets you farther afield and more problematic.
Well, it then creates a loophole or a crack for information that is contained in the ordinance, but then would not have to be captured electronically and put into this convention.
I would just respond briefly to say that if a contract or agreement between a city department and a nonprofit or for-profit entity requires them to keep records electronically, then they may be required to make those records electronically available to the city. And if the city has access to it, then it may be covered in the way that you're proposing. But I don't know that you get a way into any for-profit or nonprofit entities' electronic records that are not otherwise provided to the city under an agreement or contract. Does that make sense?
Yeah, I do, but you may be missing. Maybe you're missing a point, or maybe you're suggesting that we don't go that route. I remember in the Google Earthlink Wi-Fi plan that a member of the public had requested a lot of different documents and had cited the Sunshine Ordinance and got them specifically from the company, because the company had entered into or was in the process of entering into a contract with them, and that was deemed to be a public document at that point. And so that's where what I'm talking about is not a member of the public requesting a document from the city itself that has in its own possession, but a document that is held by an entity that's in contract with the city, it's receiving city funds, that may not be yet and then that would fall through the crack if it's not revealed.
And again, to respond briefly, I would say, except in very specific terms that I need to think about a little more, generally members of the public, in my view, cannot request, and a private entity is not required to provide records electronically or otherwise directly to members of the public. They may ask a city department for those records. If the city department has them, they generally have to provide them. If they can get them from the third-party entity, they may be able to do that. But I'm not aware that, I could write to Google or some city contractor and say, I'd like a copy of your records, and that they would just turn them over, and that I could cite Chapter 67 and they would say, sure, here they are. I don't view it as working that way.
I hear you. And that was more or less my question. Is there somewhere in the ordinance that allows for that?
Member Nate?
My recollection is that we have actually had cases like that that have come before the task force, and we have brought in outside entities, whether they were contractors or nonprofits, I don't recall, but they had agreed in their contracts to abide under to put themselves under the jurisdiction of the entire ordinance. And the task force found that, yeah, they, if that's what the contract says, then they're bound by it. And then when they get a request for a public record, and they are bound by the ordinance, then they have to produce that record, or they're in violation of that contract with the city. That's my recollection.
And I would again say very briefly, there are some of those limited instances, for example, the San Francisco Zoo or the Zoological Society. There is a provision that I recall about what was then auto return or whatever the towing contractor was about keeping records, but those are more limited. In general terms, a contractor with the city agrees to the provisions of Sunshine, meaning that any document that they provide to the city may be subject to disclosure and being provided by the city, but not that it's generally provided directly from that entity to a requesting member of the public. I hope I'm being helpful.
Member Wolf?
Yeah, you are. My focus here is more on, if you look at about 6721 E3, Roman numeral 3, that's under contracts, bids, and proposals. There's a, actually it's not, it's EF, EFI, it's I, 6724I. Neither the city nor any office employee or agent thereof may assert an exemption for withholding any document or information based on a finding or showing that the public interest in withholding the information outweighs the public interest in disclosure. So the word agent comes in. So if they hire an outside law firm to be a lobbyist, or they hire a specialist to do some level of architecture or something like that.
I just like to be afforded the same courtesy the prior speaker was.
No, I had specifically asked for his expertise.
You
Did
had?
not-
Okay. Well,
Did
that'll be
not
on the
ask,
tape.
with public comment will come,
That will be on the tape.
but he
That's okay.
has, okay.
It'll be on the tape that you asked. And I wasn't afforded the same courtesy.
So my question is more in that agent specifically, because that agent may not be a city department or what have you.
Okay, so do we want to go with the revision of, in the custody of the city and county of San Francisco, any entity therein or any outside entity to which this ordinance applies?
That's fine with me. I just want to make sure that it covers those points.
I'm good with that. Thank you.
So do we want a motion at this time to, I guess, take this to the full task force? Is that how we've handled our amendments?
Yes,
Okay.
I would so move.
Second.
Okay. At this time is, excuse me, at this time, is there any public comment on this proposal?
Yes, there's lots of public comment. First of all, my name is Jason Grant Garza, and I've been here many times before these committees, and of course, laterally, the lack of help received in them. The comments that were made earlier as far as, entities that fell out of Sunshine. I've had a case, for example, the Haight-Ashbury comes to mind, where supposedly only the 12L provisions applied. However, I was told by Mr. Nee that we could, and I do have the tape, that we could sunshine their master contract, and subsequently in a, IDR, when I sunshined their master contract, I was denied. So,
Excuse me, Mr.
there's a
Garza.
dodge going on here
Excuse
somewhere.
me, Mr. Garza. Could you-
Excuse me, I have not finished.
Well, I was going to ask if you could talk more directly into the microphone, please.
I thought I was. I don't know how much more direct I can get.
That's better. Thank you.
All right. So, the comment that the contract will be able to be looked at, by Mr. Neat, to this day I still have not been able to look at that contract for Haight-Ashbury to whether or not they had to comply with the Sunshine Ordinance. Of course, naturally, the city attorney spoke up and said that he had read the contract, but also we've also have cases where naturally the city attorney has misadvised the task force and not been held to account. Also, that brings up an interesting question. Where is the city attorney here for you to ask these specific questions regarding these legal issues, the way you should frame it, the interpretation of it thereof? Just a question I think that most reasonable people would ask, especially by a committee that's in charge of such processes that are going to guarantee sunshine when, in my particular cases, it's never happened. Specifically in Haight-Ashbury, specifically in the follow-up, specifically in all, what I consider here the Ministry of Sunshine, which of course is all about illusion and not really what the ordinance requires and what the meaning and concept of sunshine is. It's a lovely illusion. It's just not working.
Members of the Compliance Amendments Committee, Ray Hartz, Director, San Francisco Open Government. I think as I understand the term organically, if you take the example, you start up your computer, you boot up Microsoft Word, and you type a document. You don't print it out, you simply attach it to an email and send it to somebody. There technically could be argued there is no original because nothing was ever printed out. There is an electronic document floating out there somewhere in space. And I can see city agencies and departments saying, oh, there is no document because they never printed it out. In fact, I could see that as a modus operandi, which is don't print it out because if you print it out, then it's something subject to sunshine. And that's where the term organically in my mind comes in. And this actually relates to something else I was going to discuss that I feel needs to be at some point addressed in this electronic documents management and storage issue. And that is if you take the Microsoft program called Access, known as a relational database. More and more often, organizations are using relational databases because what they can do is they can go in and do what's called a query and ask for specific reports covering specific areas. In other words, I want to know how many of our employees fall within this age range and have complied with this and have done this and whatever. And all of that basic data is in the data pool, but you go in and you ask the program to go in and look for those specific items and give you a report based on those specific items. Now again, any good manager in the department will use that relational database when they need that information to serve some purpose. But if they decide to start just producing those reports and never printing them out, they can then technically argue there is no document to produce. And the law says, well, if there isn't a document, you don't have to produce it. And that, unfortunately, I can see from past experience may be something that people would be tempted to do. I will ask for the report. I will get the report and view it. And then when I'm done viewing it, I will erase it. I'm not destroying a document because there never was a document. And although that sounds like, kind of far-fetched, but it's something I saw at a company I worked for, which was AIG. They got a subpoena from the state insurance commissioner for a specific report. They were able to produce the report because I had seen it, and they had produced it and had looked at it, and they realized how it was going to negatively impact the company. So they simply ordered it deleted. And then when the insurance commissioner asked for the document, they said there is no such document.
Thank you. Are there additional public comments?
There is. David Pilpel. Let me try to be brief, and if you have follow-up questions, we can go there. First of all, I think that the language here does need some more work. I appreciate what Member Nee has already done to improve it. I think at a minimum, organically and some of these other terms need to be defined here because they are ambiguous. Even if they are clear to some, they are not going to be clear to all, and clarity is highly important here. Secondly, I am of the view that this language would be very much in addition to the ordinance, and I was not exactly clear from your discussion if this would go as part of the larger package, if this would be a standalone amendment, if you were contemplating the board enacting this, or where this is going. I guess my view is that this would need to go to the voters in some fashion because the existing ordinance sort of covers much of this, and this would be a distinct refinement and shifting burdens in a certain way. Further, and again on the clarity of the language here, I'm not entirely sure exactly. I get that there's a problem that one is trying to solve. I'm not sure exactly what that problem is, and so it's difficult for me to see that the language here actually solves that problem and doesn't create its own. Separate existing legislation requires departments to maintain a records classification and destruction schedule. This sort of suggests that all electronic information would be kept perhaps indefinitely, but it's not that clear, and I'm not sure that anything in Sunshine could necessarily overcome the department head's responsibility elsewhere to classify and ultimately destroy records when they're no longer needed for various reasons. It further doesn't make a whole lot of sense to me what the reference is to the index of records. The index of records was created separately to classify types of records so that one would have an understanding, for example, at the police department or any number of other departments, what types of records that they keep, so one could ask for a subset of records and understand their classification scheme. And just to continue, reference to the website, it sort of suggests that a department would put all or some electronic records on its website without necessarily referring to redaction. Could I continue, or do you have a follow-up question?
You could continue your thought, please.
Thanks. With respect to redaction or other requirements with respect to that electronic record. So I think that this needs some further work, and I would actually seek some clarification from you about exactly what you're trying to solve and how one could try to get at that. I have had problems, as perhaps we all have, with electronic records. I actually appreciate Mr. Hartz's comment about queries. That seems to be one of the latest bits that departments use for records that are stored electronically. Well, we have to write a query. Well, if we have to write a query, then maybe we can charge you for that. Well, if that's the only way that the records are stored, even if you have to write a query, no, you can't charge for that because that's the only way to get at the records. Sorry. But some of the clarity on getting through those issues is missing here. And if I could just comment on the point on 67.24I, the GH and I in 67.24 was added so as to abrogate the balancing test, either invoking 6255 or some other similar scheme to balance the public need in, or the public interest in disclosure and the public interest in non-disclosure. I think the language that was used, office employee or agent thereof, was just to be broadly inclusive. My view is that it's actually a department head under both the Public Records Act and the Sunshine Ordinance that's ultimately required to make a determination of whether a record is public and to make it available. So I don't know that that's a delegable power to an agent in the manner that the language may suggest. I don't know if that helps. I can answer any further questions that you may have.
Members?
I'll wait till the rest of public comment.
I'll be
and then
here.
I'll have some more
Thank you.
discussion.
Is there additional public comment on this item? Member Wolf?
Okay, so I have a couple items. With regards to storing things indefinitely, or whether things are outlined based upon a department's head's responsibility to create a retention plan, or whatever that is, overarching retention plan, based, it's coming down like some sub-department or division of a larger agency. The agency might have a retention policy, and that may trickle down to all its sub-levels. This was meant to correct what doesn't exist. And it's also meant to address what is about to come. Briefly, the city has adopted a new system for records retention. It's based on a taxonomy type of system that's categorical, which makes it a lot easier to do those queries or just do a find for documents. The idea is that any electronic document would be stored there. That is where people store their documents. It's based on this particular platform. And they could then, at that time, make it public. And if they make it public, it could then automatically, or as we like to say, automagically, appear on the website without any intervention from a webmaster. So that way, it's an interesting automation because it automatically makes a public document that is created by a custodian or by any staffer automatically public and available to the public on the website. And that's the intention of, one of the intentions of having this included, is to try and encapsulate or cover that what is about to come. And it's still being kind of built. So yes, that's why I don't, there is no real mention of time frame, because the time frames would still be managed by the existing retention policies, which may exist, guidelines may exist, or laws may exist elsewhere. Second point is with regards to the index of records, we've had a terrible problem where people that are making requests for records, they ask for certain records, but then staffers can't find them because they're new and they don't know where to look. So the document is buried in some file cabinet or in somewhere on a shared drive, and they just don't know where to look for it. There could be hundreds of thousands of records going back 10 or 20 years. So the idea for here to make specific notice of the index of records is to ensure that it's followed. Now, again, with this new system, that new system would be contained for every single department. And we've seen some departments actually do it. They actually list the index of records on their website. Not that there may be any records there, but they at least have the index correct. While in other departments that do a fairly good job of creating a taxonomy and they have records online, do not follow an index of records to make it easy and obvious and intuitive for a user to navigate and know and be able to find those records. You find a link in the middle of a paragraph that refers to a PDF on some very important project. It's buried, as we like to see. So the idea of focusing on the index of records is to create a standard of taxonomy that appears to the public and that helps maintain organization of records, public documents within any department or entity. The question about queries is a good one, and there it goes back to some of the references in this entire document with regards to 3 different types of data that we're talking about. What's mentioned in here is electronic documents. There's electronic public information. and records. And so the question is there a distinction between those three topics? And I think in A, where it says all city entities shall mean to store, backup, and restore all electronic documents, I think documents is really more of the physical piece of paper versus information. We've had this discussion many times that the Sunshine Ordinance is really looking at making sure that all information is public, no matter in what format or in what medium it's created in. So a document could be construed as being a piece of paper versus, as we're talking about, a query of a database to produce a report is information. So, or it's a record. The organization, the end result of the report is a record versus the information is all the little bits of data that exist in the database. Do you follow me? There's kind of a, it starts out with the information in a spreadsheet, and then you query it, and you collect all that information based upon that query into an organized record, and then when you print it out, it's a document. And that's the way I'm kind of looking at this. It's a technical graduation.
Right, we had a case just recently about the Office of the Controller, and I remember someone from that office telling us that it took a great deal of time to create a document, and so I think that's what she was referring to. All of the information was there. There wasn't a place where she could go pull this document. She had to organize it. It was like doing a query of an Access database. So we have to make sure that the ordinance is crafted in such a way that all that is covered. Otherwise, as Mr. Hart says, there's a big loophole. So.
I have a question through the chair to Member Need. Do you remember if there was any discussion about whether something like this, in your years on the task force, something like this, because it's more or less contained, whether it maintains the context of what already exists? So the question would be, does it have to go before the voters, or is this really just a more expansive description based upon changes in the entire environment in the city, on its filing system? So its filing system changed. It doesn't, by adding this, it doesn't necessarily change the context or the substance of the section that we're trying to insert it in.
Through the chair, I wish the city attorney was here to join that particular discussion.
Because then I would say set it aside and let's move it through the Board of Supervisors.
I mean, if you look at what Supervisor Mercarimi did with the requirement on video recording, streaming, et cetera, that was the purpose of that was to strengthen the ordinance. It was done in the context of the intent, the letter and spirit of the ordinance. And it is possible that this could be interpreted the same way, but I wouldn't want to. I wouldn't want to make that call on my own. I'm not an attorney.
No, I understand. I'm just
I would like to
brainstorming with you.
Yeah, no, I understand. I appreciate it, and I appreciate you drawing me in on it. I would strongly urge that this question be put to the city attorney and or to the new attorney member of the task force once that person is appointed, and we can hope that occurs this coming Thursday, and in subsequent actions by the full Board of Supervisors. We can hope that the attorney member is seated by the time of the June meeting. You know, it's certainly worth considering if we could get the full board to do that.
Well, between now and the June meeting, we could try to figure that out, because this would have to go before deliberation of the full task force anyway.
Yes, it would.
So I think it'd be prudent of us to at least investigate.
We could, one of us could send a memo on it, a question on it to, perhaps to DCA 3.
Mm-hmm. Will do. I can do that.
Okay, so Member Wolf, you'll send a memo to DCA 3. Okay.
Right. Yeah, we'll take no action on this, except to recommend it to the task force. How about this? I move that we recommend this to the task force.
I think we already had the motion.
Have we already
didn't
had
we?
motion on the floor? Okay. Let me just add one thing. In A, the word store, backup, and restore all electronic documents, I would like to replace that word documents with information, because that's what's really flowing in the rest of the document. Is that acceptable?
Maker accepts.
I like the change a lot.
Yeah?
Yeah, I
Okay.
do. I think that will be helpful down the
Right.
road. Ms. Osbury, would you call the roll, please?
Do we have public
On the
comment?
question?
Oh, we had public comment.
We had public comment already.
Did you want to, let's have Mr. Pilpel wanted to respond on my question, since he brought it up on all these points are based on his public
Okay.
comment.
Go ahead.
Just very briefly, and you may want to take some notes on a couple of things to go review. In the state law 6252, E and G, which define public records and writing, are, I think, germane here. And in the ordinance 67.20B, which defines public information, putting those pieces together, I think, helps distill what is information, what's a writing, what's a record. When you get to the question of an electronic document or electronic data, it gets a little fuzzier, which is why I, again, suggest more definitions here. If you really are referring to electronic information, it's a bit ambiguous what that then refers to, because it's a new and sort of broader concept. I'm not against it, I'm just...
I understand, but
Okay.
it sounds like what you're saying, that a kind of a paragraph defining terms would be...
That would be helpful.
Okay.
And then I would
that can be done.
Okay, and then I would also refer you to 67.21K and L, and in particular 21L, inspection and copying of documentary public information stored in electronic form shall be made available to the person requesting the information in any form requested, which is either da-da-da-da-da.
Yeah,
So,
the problem with that is that that's the information that they have in front of them. We've had problems with information that is like been deleted, that was requested, that needed to be produced for a particular situation. And so there was the response from the respondent was, we don't have a backup of that. Now, we know that there are
Okay.
backups, because we've had a situation where RPD had produced backup of emails that had been deleted.
I understand, and
Okay.
now I'm better understanding the problem that you're attempting to
That's
address, and I think that should be more clear, because, again, it is not obvious that that's the problem or part of the problem that you're trying to solve.
But I don't know we need to describe the problem except to provide the solution and just put it into law, and so that people follow it this way, and that's the way it is.
I'm just saying, I think it creates ambiguity and perhaps unintended consequences to not try to make clear what you're trying to solve for in this context.
Okay.
I mean, that's why
I'm trying
Mr. Hartz's comment about queries, I'm thinking now about drafts. You know, I mean, then you get into
Right.
lots of other things, you know, taken
I
to
see
an
what you're saying.
extreme. if one were a department head that wanted to obscure and delay access, one would say, oh, that's still a draft.
Okay,
Well, it's been 2 years. Well, it's still a draft. We've
I-
never finalized it.
I get the concept. The question is moving forward to action. I think an explanation in the preamble might be suffice.
I'm not saying how, I'm just saying.
I understand.
it
I get
seems
your
like it would
concept.
make
Well,
sense.
okay, I'll,
Okay, so you've got a couple of references there.
got it.
Thank you for
Okay.
the opportunity.
All right, Ms. Osbury, would you call the roll, please?
For clarification, the motion on the floor is to amend the proposed sunshine ordinance and to refer it to full task force? Is that the motion?
With the, and the amendments that were made as amended.
As amended, okay, all right. Member Nee?
Aye.
Member Wolf?
Aye.
Member Chair Washburn?
Aye.
You have 3 ayes.
Okay, at this time, I'd like to, Ms. Fosbury, would you call item number 11, please?
Public comment?
Okay, at this time, we'll hear general public comment for items not on the agenda.
Hello, my name is Jason Grant Garza, and I've been here many times, and one of the items that's not on the agenda is this unfortunate belief that this is the final forum, that there are no appeals, that everything that is issued here is correct, has been verified, on and on. What's happened recently in the past, for example, in my particular case, is 11081, 10038, 11070, 11099, has been the fact that incorrect decisions have been made. I've brought it to the task force attention, and naturally, those have never been followed up upon. Right now, specifically, I was listening earlier to a comment about it being said that records, that if they cannot produce, the Sunshine Task Force cannot order them to produce that. That, however, is a fallacy, because in my particular cases, those records must be there by law. So, in order to say that they can't produce them, leaves a convenient out for this body to not perform correctly, because, as I've stated many times in my cases, those records must be there by law. And when the other side says, well, we just don't have them, this farce allows it to get away, as opposed to saying, excuse me, but that's supposed to be there by law, and make that finding and say you did not provide the record. However, since there's an easy out and no accountability at the Ministry of Sunshine, the illusion just continues.
Thank you. Is there additional public comment?
Can I get the overhead? This document is dated May 17th, and it's going to be presented to the Library Commission.
Before you start, can you move it to the right a little bit? There you go. No, a little to the right, a little more. There you go. Thanks.
This document is going to be presented this coming Thursday to the Library Commission. And one of the reasons I'm bringing it up now is the fact that I have been on a quest for documents from the library for over 9 months now, and subsequently have had produced certain documents. Down here on the bottom of the sheet, you see some numbers there that say $5,170,000 from the Friends, $2.5 million from SFPL, and $1.1 million from the Department of Public Works. My document requests finally have gotten from the Chief Financial Officer substantial documentation which shows the bottom 2 numbers are actual real donations. I have also gotten admission from the Chief Financial Officer of the San Francisco Public Library that $5 million figure has no supporting documentation. So this document is being presented to the Library Commission, and by doing that to the public, saying that the Friends of the San Francisco Public Library have donated $8.8 million to this BLIP program, which this is a legal accounting of, where they are now admitting that that $5.1 million, or almost 60% of the money, they have absolutely nothing to show that they got that from the Friends. So while some may, say, well, you can't get anything with the Sunshine Orders of Determination, I think I got these numbers finally because Mr. Herrera knew this was going to go to the Ethics Commission, and he had withheld these documents for over 8 months at that time and finally decided to pony up. When he did pony up, I got 2 of the numbers verified to the dollar and an admission by the CFO of the San Francisco Public Library that that $5.17 million figure listed as the Friends donation has nothing to support it. So thank you for your assistance. And the last thing I'd like to say is the change in administrator is greatly appreciated. I would like to publicly acknowledge that Ms. Osbury is very timely in her responses, and she is also doing, I think, a really credible job in not only supporting her own position, but in supporting the task force and making it live up to its own ideals, so that you're not asking other bodies to do something that you're not doing.
Is there additional public comment?
Yes, good afternoon. Peter Warfield, Library Users Association. The discussion that you had on a previous item regarding an amendment has triggered in my mind the larger question of how well is the task force serving the public. There are many times when the task force has discussed through specific cases the interpretation of law, including asking the city attorney who sits with you for an answer to a question. And very often those discussions that you have, sometimes embodied within a decision about a particular case, sometimes not, are actually very significant and very important. And I've spoken before about this. There does not seem to be a way that these issues and these decisions and these discussions, for that matter, are tracked so that people can have some sense of what is a likely guideline or a likely interpretation. With respect to previous complaints that Library Users Association has had, what are the interpretations with respect to claims of privacy on redacted materials? Can certain things never be redacted? Is it on a case-by-case basis? Is there some other operating principle when one person says, well, if we look at this section here, it says such, and somebody else says, yes, but if we look over here in the state constitution, it says such and such. I think it would be very helpful if the task force would see to it that important decisions and interpretations be published, not just within an order of determination, if that's where it even can appear, but separately in some fashion, either within the minutes or preferably even in a separate part of the website. In general, I'm very disappointed that, just to give you an idea, tomorrow the Arts Commission is going to take 1 minute to pass on a consent item the last approval at the Visual Arts Subcommittee, Visual Arts Committee, which is a subcommittee, the very final approval for the replacement of the front of the Bernal Heights Branch Library mural. They don't even plan to discuss it unless some exception happens. And all throughout the process, certainly Library Users Association has been attempting to try and move things forward with respect to the many, many illegalities which we have asserted, and many of those which you have found. And these long delays are very exhausting and very discouraging, and actually very much torpedo to some degree the efforts that we've made to show that the Arts Commission has been doing illegal things. The long delays are very painful for the public process. Thank you.
Thank you. Is there additional public comment?
David Pilpel, perhaps my last comment for today. In as much as the last meeting on April 17th apparently was canceled for lack of a quorum, I'm just wondering what this committee's intended follow-up is to the joint meeting with the Ethics Commission. I'm sorry I was not able to attend. I do intend to watch it when time permits, and I get that there will be at least some change in the task force composition in the near future. But my understanding was that there was some conversation and that there was going to be some sort of follow-up from them, from here, from somewhere, and I'm just kind of wondering where that is. I know it's not on the agenda, so I'm not asking for a lengthy discussion, but if there could be some just brief explanation of the intent going forward on that point, I'd feel illuminated, and thank you.
Pardon me? Right, we'll talk about that briefly under number 13.
Okay, I wasn't going to stay, so maybe I'll find out later, but thank you.
Okay. Just very briefly, there really
Okay.
isn't anything to add. My feeling was that the Ethics Commission was going to take into account our ideas and the exchange we had at the joint meeting. It's their regulations, so they're going to be drafting another version of them. That's where it was left. Member Wolf?
If I could just elaborate just on one point that was significant, is they agreed to take any referral that was not official misconduct.
Or willful?
Or willful failure leading
Right,
to
okay.
the 6734.
34. Right.
Anything other than 6734, they felt that it was well within their jurisdiction and that they could handle the enforcement if we sent referral to them.
Okay.
So
Yeah.
if there was a violation of 6721E,
Whatever.
they would enforce that.
Okay. I mean, my understanding as well was that they were going to do another draft.
Yes.
And that draft was likely going to land here or with the full task
Yes.
force, and that there'd be another opportunity, but perhaps not an extended opportunity for full discussion. I don't know. I haven't seen it. I don't know that it's been baked.
We don't have it either. So I don't think.
Right.
I think you're right. It
I
hasn't
hear they've
baked.
been busy with some other thing going on. So
I imagine they have been.
yes.
Talking about official misconduct.
I don't know what you're talking about. Thank you very much.
All right. Ms. Osbury, would you call item number,
I just have a couple of things I want to just say.
Yeah, item, got to get to them.
Okay. All right. I'll mention them at the end of the meeting.
Okay. Ms. Osbury, would you call item number 8, please?
Item number 8, file number 11081, continued hearing on the matter of scheduling HIPAA expert to discuss a matter related to Jason Grant Garza versus Department of Public Health.
All right. This item is on the agenda for the express purpose of reaching a closure, to use every popular word these days, on this item. And Member Wolf?
Sure. With regards to this, my insistence before I took a leave of absence for several months, and the attempt to try and get a HIPAA expert to come and help us with understanding about the availability of a person or patient who requested their own records and the requirement that is placed on other individuals other than the patient to sign a specific form. Unfortunately, the person who I had set up to come had left that organization, and the organization had no one that they could rely on to send. I've queried other organizations. I've queried law firms. Law firms say, well, that will mean paralegal time, And if we were willing to pay for it, they would then send somebody over, but it wasn't something that they necessarily could just show up and say that this was true or that was not true. So, but the purpose of this was to try and inform the task force of this particular instance, because there was some difference of opinion between myself and others, our legal counsel, and it just was kind of very not understandable what the law had to be interpreted, so to speak. It didn't actually say patients don't have to sign this. It talked about people other than patients that had to sign it, but it didn't expressly say that. So also in this particular case, 11-081, the task force did not take up the issue of the requirement for that, and so it's not part of the record. So I don't think there is much more to discuss on this unless the task force wants to take it up. I mean, I think our charge was to find a HIPAA expert to discuss the matter, and then after we found out what the information was, then make a recommendation to the task force, and the task force would then, I don't know whether it was to call the chair or whether it just wasn't, it was just left hanging, would then be able to take it up. I think that was the, I haven't had a chance to listen to the tape playback, but that was my recollection. So I will continue to try and find an expert if I am reappointed this week. Well, it would actually be the following week. We'll see. It's not easy to find. It may just need to be like in the FAQ at the Federal Department of Health that oversees HIPAA, or the AG's, the U.S. Attorney's Office, the DOJ. I don't know how or where, but I'll certainly continue to find somebody that can answer that question. Because I think it's an important one, especially when these kinds of issues come up. And they do from time to time.
Renee, do you have anything?
No, it's unfortunate that the expertise we seek doesn't seem to be readily available. It's particularly from the standpoint of trying to serve the complainant here. It's.
If I can just add, I believe that the thrust of the complainant's request in the hearing that has happened and his continued persistence has proved to be successful, in that they have more or less agreed to hand over the file that he had requested without a signature.
Granted, but similar cases could come before us, could come before the task force in the future, and it would be useful to have that guidance going forward.
I agree with you. I'm not in any disagreement. I'm just saying that one of the purposes of bringing somebody to the fore in this forum is to more or less compel them to produce the documents that they are in violation of their withholding. And if that comes to pass after coming through this entire process, then justice is served. Okay? The parties may not agree with how or why or what decisions the task force may have come up with to arrive at that point. But if that point does arrive, then the process is worked.
Agreed.
Right. Yeah, I for one am disappointed that we haven't been able to schedule this expert because I was very curious, and I think it's a very important matter. and I hope that this is something we'll remember to pursue down the road. But as far as this committee, the matter is ended at this point because
I'm sorry, is it not on the agenda?
the item is on the agenda and it's
And I, the complainant, am here to respond to the item on the agenda and present what needs to be presented.
excuse me, sir, we're not having a hearing on this. This is not a hearing.
This is the compliance and amendments to which I was sent, and I have the tape of the hearing, which I was going to play. Unless, of course, you don't want it on the record, please let me know.
Excuse me, this was a continued hearing on the matter of scheduling a HIPAA expert.
No,
So
madam.
this is,
No, madam. That's not what it is. I have the tape from the November hearing. That's not the way it is, and that's not what I agreed to, and it's on tape. So, no, madam. You aren't. Is
excuse
this
me.
being taped?
Yes,
or
it
will
is.
this not be taped like the last one?
This is being taped.
Thank you.
And we have reviewed the order of determination, which was clear that what was to come before this committee.
The order of determination that's incorrect that I pointed out many times.
Sir, we're going by the order of determination as it
That
was
is
signed.
incorrect.
This is not the place to discuss that.
That's your opinion. I disagree.
Excuse me, I am going by what is on the agenda. What is
So am
on the
I.
agenda?
That's why I'm here. The complainant. For this matter, for the follow-up, haven't followed all correct procedures,
Excuse
haven't
me.
been here before, and your failures continue to occur.
As I said when this item was read, we are here for the express purpose of discussing this scheduling of a meeting of this expert. This is the only reason this item is on the agenda, sir.
That is your interpretation of the meaning of those words. That is not the interpretation
This
of my
is-
meaning of those words.
I am chairing this meeting, and
That's
this
fine.
was agendized in this way, noticed in this way. This is what it means.
And why is there an asterisk by this? And why was it agendized late? And why is it not on the original one that was outside, which of course I've kept a copy?
There's an asterisk because it was added late. It was
Thank
added.
you for violating my due process.
Actually, that's incorrect, because the agenda could be revised before the 3
I'm
days.
sorry, we're not speaking to the subject because we're not speaking of this, remember? Remember, we're whitewashing over this. It's not on the agenda. Thank you, Mr. Wolf, for all your lack of help.
Ms. Osbury, would you call the next item on the agenda, or item number 9, please?
Madam Chair,
Yes.
Yeah, public
I'm
comment.
sorry.
I suggest public comment
Yes.
on item 8.
I'm sorry. Could we have public comment on this item, please?
Peter Warfield. The question I've got actually is when I see a revised agenda with an asterisk, I appreciate that asterisk seems to say that item 8 is the change, but it's not clear to me when that happened and whether there was proper notice for the public. The other thing is that I appreciate the order in the court necessities, but I do think that the members of the public might be informed that however incorrectly they think the item is being handled or interpreted, that they do have a right to make public comment and to get 3 minutes for that. So I think that might defuse some of the heat between the chair and the previous member of the public if he would be informed that he has 3 minutes for commenting on the agenda item as he wishes. And I do hope that you will be able to find somebody promptly as you've been talking about. Thank you.
Thank you, Mr. Warfield. Is there additional public comment? Members? Okay. Ms. Osbury, would you call item number
9.
number 9?
I just want for clarification, there's no action or motion on 8.
Correct. I mean,
Right.
I would just say continue the item.
It continued at the call of the chair, which
Yeah,
means
that would be
it
fine.
will not appear,
And
continue
it will
to
never be
appear.
heard.
Yeah.
Item number 8, file number 11098, hearing on complaint filed by Ray Hartz Jr. against Luis Herrera, city librarian, for allegedly not including a brief written summary of comments into the minutes.
All right, I see the complainant here. I don't see anyone from the library. Is that correct?
I think we should just proceed.
I think we should proceed, right?
Members of the committee, Ray Hartz, Director, San Francisco Open Government. I had really sincerely hoped that Ms. Blackman, or at least someone from the library, would have deigned us with their appearance, because I'm really confused as exactly what their position is at this point. On this particular complaint, it was a complaint about additional violations of the ordinance and the directions of this task force. 10054, as revised in 11054, were on specific agendas in which the summaries I submitted were not included in the minutes as were directed by the task force. This complaint was after they had already received those determinations and then went on to additional minutes and continued to ignore the rulings of the task force. Now, this is something, and again, I'm going to use the overhead. I have started submitting all of my 150-word summaries with the little boxed-in information at the top, so everybody that I give it to, whatever body they're in, it's very clear to them that the intention and the previous rulings of the task force. I then put my 150-word summary at the bottom, and that is what I asked to be put into the minutes. Now, in the cases, or in the case of the minutes that are before you, they have not gone back and done anything to correct the attachment. They're still attached to the minutes, as they are with Mr. Chafee puts in 150-word summaries, and they also attach his. However, again, I'm in receipt of a packet for the meeting Thursday, and what they started to do is put in this. Mr. Hartz read the following statement, and then they quoted verbatim. And it is in the minutes where we have all intended that it be in the first place. The contradiction, though,
I really didn't have enough time to read that. Was this? I didn't recall that this was contained in the packet either.
no, this is something I just received in the mail today.
Okay.
And what I'm saying is that in the case that's before you, they did nothing to correct and follow your directions. They basically just left them as attachments. Now, in this minute, and there was one previous one where I submitted a 150-word summary, they included it in the body with the statement that Mr. Hartz read the following statement, and it is verbatim what I submitted to them in my summary. The problem is another member of the public submitted 150-word summaries, and they are still putting his as an attachment. So I don't know whether they're doing some sort of a Solomon thing where we split the baby, and they're putting mine in because I read it, and then making a distinction between the two summaries provided and saying, well, this guy read the summary, so we'll put it into the minutes, and this other person didn't read it, so we'll attach it to the minutes. And so, again, I was seriously hoping that they would show up and explain what the heck that is they're doing, because it seems like, as I said, they're trying to split the baby. Now, I really do feel that this is a direct result of the fact that 2 letters of referral, one was sent to the Ethics Commission and one was sent to the district attorney, based on case 11054 and their failure to follow that previous rulings. And I think Mr. Herrera at the library is getting nervous and as a result decided to do this little thing. So I'm not exactly sure what to say to you. I have my real feeling is the intention was always, if I don't like the way they summarize what I say, the Sunshine Ordinance gives me an added layer of protection, and that is I may submit my own 150-word summary, which is included in the body. And up until this recent change, they have continued to attach it and put their own interpretation of what I said, which often has nothing to do with what I said. In fact, in most cases, if it was anything that they considered to be negative, it would be edited out. And so that's why I continue to say they're, in this case, they're still not doing anything to correct it. And going forward, I don't know what they're intending to do.
Okay, is there anyone here to offer evidence in support of the complainant? Seeing none, the respondent is not here. Members?
Facts and evidence for the respondent.
Are there anyone here to offer facts and evidence in support of the respondent? Okay. Members? Member Wolf?
So, Mr. Hartz, can I just ask you a question? So are you, by what you showed us, you're saying that they included your testimony in the minutes, but they didn't note, they attached it to the minutes, but they didn't notate where in the minutes it was supposed to be? I'm a little confused.
Okay. In the agendas that are on the complaint before you,
Right.
they did nothing to change it.
Okay.
They're still attached to the minutes as they have been doing.
So they didn't make a correction?
Yes.
Okay.
And I believe they should be found in violation, and it's a willful violation because basically they just continue to ignore what you've told them multiple times. Even though I've gone before them and said, look, even the city attorney has been told to stop advising people that attaching them is okay. And they just kind of don't say anything. They don't respond. They don't discuss it. They don't do anything. And yet now all of a sudden in the last couple of minutes, they have started to do this while leaving other folks' 150-word summaries attached.
Oh, I see. Okay.
So,
Now, where you just said something significant, said that the city attorney had told them that it was okay. Where was that transaction? Was that a written opinion of the city attorney? Was that a phone call? Was that?
This is something that I have gone back and forth with the city attorney's office because the city attorney sent me a copy of a document that their office produces saying requirements for a city attorney opinion. And it says specifically what you have to do to consider something from the city attorney's office a legal opinion. And I said to them, all you've given them is a memo which says the good government guide says this. And even reading your own direction, this does not qualify as a legal opinion, but you keep presenting it as one. And the library keeps trying to rely on it as one.
But I thought I heard you say that the city attorney told them that it doesn't matter which way they can do it by inclusion.
I don't, if I did say that was a...
That's what perked me up because it sounded like you said that the city attorney kind of
I think
told
what
them
I
it was okay.
no, I think what I said was that Luis Herrera had made this change as a result of the fact that 11054 had been referred to the district attorney.
Right, I got that part.
And the ethics commission.
Okay, then I misheard because I thought that you specifically said that the city attorney had told them that it was okay, despite the good government guide, that it was okay.
No. What I said was, despite the fact that in case, I think it was 11071, you and this body, or the full task force ruled that the city attorney was wrong in advising people that attaching them was okay. And I've even, I let the library commission know that. I said, I've even told the city attorney that that's not acceptable.
Okay, I just wanted it to be clear. Thank you.
Member Ning, do you have anything? So it looks like they've started sort of doing the right thing. Not completely, They haven't complied with this order of determination at all. So I'm thinking we need to refer this to the full task force with a recommendation that this go to the Ethics Commission and the district attorney. But let's, do you have anything more you want to say on rebuttal?
The real problem I see with this as it stands is the fact that they have repeatedly, in every single case, come before you and said, the city attorney says it's okay not to follow your orders of determination. And they do not discuss it at the Library Commission. They do not have any sort of a public, they've never had any sort of a public discussion as to the real purpose of this. In other words, if a citizen exercised his or her rights under the Sunshine Ordinance to put in a 150-word summary and wants that summary in there to reflect what they actually have to say, why do they have such a problem with that? Why are they so determined to keep it out of the official record? The only thing that I can say is my experience with them has been that they do not like to be criticized. And they want to ensure that although they cannot stop you from criticizing them verbally, they can ensure by making this an attachment and putting a disclaimer on the beginning of it that it is discounted by people who might read the minutes. And in its place, in the actual minutes where your comments are made, they substitute their interpretation in sometimes what I have to say honestly is misinterpretation or misrepresentation of what you say to conform and to edit out, to censor what the criticism is. Obviously, if someone gets up and says something really great, they'll probably put every word of it in. And they continually, when you go before them, complain about the fact that members of the public talk too frequently, they talk too often, they raise questions that they say you're not being nice. I mean, there's such a long public record of the fact that they just don't want anybody making public comment of which they don't approve. In fact, that's the statement they put in front of Mr. Chafee's continued things, that this was neither authorized nor approved or whatever it happens to say. And I think that's done as a sort of disclaimer to the public to say, well, this really isn't anything we looked at, so you can take it with a grain of salt. And number two is they seem to still have the idea they have the right to approve public comment. And they don't. Members of the public have the right to say anything they want, and they have the right to have that fairly represented in the record, not marginalized as an attachment. And I think that is the decision this body has made very rightly. And I think it does go to protect the right of dissenting opinion to be represented accurately in the official record of city meetings.
Thank you. Do I have a motion? Member Ning?
Move to refer this back to the full task force with a recommendation that this be referred to the Ethics Commission for noncompliance with the order of determination, also with a finding of a violation of Section 67.21E for the respondent's failure to appear at this meeting.
Second.
What about the district attorney? Do we want to add the district attorney to be consistent with our earlier recommendations and what happened with the other orders?
Do we see a criminal aspect here? The district attorney would take it if it found there was a criminal aspect. Do we have that?
Well, I mean, I think, any I mean, if you just go by CPRA and the Brown Act, any violation of that could be deemed a misdemeanor. And it's kind of like the same thing we were dealing with the Ethics Commission. They were basically a little confused as to what else would we send them other than just official misconduct. And I think we convinced them rightly that we could send them anything. And I think the same goes for the district attorney and the AG's office, because they're specifically named for these kinds of items. So I don't see a problem with it, sending it. They could just not do something as they have. But I think I don't know, either way.
If Member Wolf wants to add that as a friendly amendment, I'm the chair, make rule accept.
Okay, let's do that.
Do we have public comment on this motion?
Peter Warfield, Executive Director of Library Users Association. I'm not very familiar with the specifics of this particular case, but I can tell you that I would support the strongest possible motion that you might make and hope that you go ahead and carry it through. I think it deserves actually a little more of an emphatic kind of a feel to it, and also raises some other questions about ancillary illegalities. So first of all, to give a little background, predating Mr. Hartz's arrival regularly at the Library Commission, they have been playing games for years with this section of the Sunshine Ordinance. They have said, for example, to people, if you don't send it to us electronically, we're not going to put it in. Sorry. When you read the minutes, there is such a marginalization. The minutes end. Here is the current minutes for the most regular, the recent meeting for coming up Thursday for approval, April 19th minutes. So here at the end, there's adjournment followed by, please note. So it ends like a letter or any document would, with presumably a signature, Sue Blackman, Commission Secretary, and goes on to say these are draft minutes and so on and so forth. Then it goes on with explanatory documents. Those are not legally required with minutes, and they're not even mentioned in the minutes by and large. They are mentioned in agendas and are required and are provided to some degree with agendas. So there's all this stuff. There's all this big, heavy paragraph going on with details that most people would say, oh, yeah, I don't want to read this. This is like the boilerplate that goes on your agenda and everybody else's about perfumes, etc. Addendum. These summary statements are provided by the speaker. Their contents are neither generated by nor subject to approval or verification of accuracy by the San Francisco Public Library Commission. And only after that basically kick me sign pasted to the back of Mr. Chafee's comments do they then give his comments. Now, are the library commissioner's comments verified for accuracy? Nope. If I am included with in some fashion as a summary, they're not verifying the accuracy. And in fact, they're sometimes just plain wrong. Too bad. That's what the minutes do. But they are marginalizing these minutes. They recently had minutes coming before the Library Commission either didn't have any attached or had the wrong dates for the anonymous citizen. They didn't even realize that that's what they had brought to the commission. So when the anonymous citizen mentioned it, they then decided not to have it at that meeting. I wanted to point out that the non-discussion at the Library Commission, as far as I'm concerned, is a conspiracy. It's a decision without a vote and without notice and without discussion. And if you look at they're playing games with...
Excuse me, would you?
Okay.
Yeah.
So the conclusion is this. I think they're playing games. On your page 129, decision and order of determination, they're including Mr. Hartz, but not others. And if you look on your page 135, there's a reference from Sue Blackman to the city attorney's opinion, but it's not shown. It's in the paragraph just before conclusion.
Okay, thank you. Ms. Osprey, would you call the roll, please?
Member Nee?
Aye.
Member Wolf?
Aye.
Chair Washburn?
Aye.
There are 3 ayes.
Ms. Osprey, would you call item number 10 with my apologies for pushing this up to the last minute. I did get your note that you had to leave soon.
Item number 10, file number 12001, hearing on complaint filed by the Library Users Association against the Arts Commission for allegedly redacting requested speaker cards information.
Mr. Warfield? You have 5 minutes.
Thank you, Madam Chair. Peter Warfield, Executive Director of Library Users Association. On March 7th, you heard this complaint number 12001, which concerned the Arts Commission redacting contact information on speaker cards that they had collected during certain meetings and which we had requested to see. As you know, they did not tell us that there were redactions. They did not explain the redactions. And in fact, the only way that I knew there were redactions was not because I was given, when I came to the Arts Commission, photocopies of the speaker cards, 2 per page, but when I insisted on seeing the originals, at which point the Secretary of the Arts Commission went away and came back with envelopes containing speaker cards that had white paper pasted over the information. You found the Arts Commission in violation of 67.25A. I'm reading now from the Order of Determination, which was issued April 5th. The task force finds SFAC, the Arts Commission, in violation of Sunshine Ordinance Section 67.25A for failure to respond to the immediate disclosure request in a timely manner. 67.26 for failure to keep withholding to a minimum by improperly redacting the information from the speaker cards. And 67.27 for failure to justify withholding the redacted information. Then you go on to say, the SFAC shall release the speaker cards requested without redactions within 5 business days of the issuance of this order and appear before the Compliance and Amendments Committee on April 17th, 2012. And that was a 7-0 vote. I'm a little bit disappointed that the email that I sent to the administrator for distribution to the body apparently was sent to your Compliance and Amendments Committee folks, but not as I requested to the full task force, as far as I know. But more importantly, okay, she says it was, but more importantly that there's nothing here to show what our update said. And again, as I said a little bit earlier in public comment, there's a whole range of things that I think are a disappointment. And one of those is that there is not clearly a timetable provided to complainants telling them what the timelines are, particularly deadlines, for getting material included in the agenda packet. So it's very simple. To my knowledge, we have not gotten anything from the Arts Commission within 5 days, nor any other time related to the speaker cards. Not an explanation, we're not doing it, not the unredacted cards, and so on and so forth. So to my knowledge, there has been nothing at all coming from the Arts Commission in response to this order of determination. And that's what I briefly sent to the members so that you'd have it in advance if for some reason I couldn't come or if you wanted to see it and might have some questions about it. I think this is a very cynical approach from the Arts Commission to cut off people from each other. They don't want the many people who oppose what's going on with the destruction of Bernal Heights Branch Library mural. They don't want those people getting in touch with each other. They don't want those people talking with each other. They don't want basically those people organizing anything that is in opposition to their plan for the destruction, complete destruction of the mural and its replacement by a very bland new product that will generously benefit certain people, including very amply financially. So without getting into Motives, I see a wrinkled brow. I'd be glad to get into it, but let's stick with the specifics of what's before you, and that's pretty straightforward. There's simply been no movement, to my knowledge, since the time that you found this, and we're now in a position where tomorrow the Visual Arts Committee, which does the detail work on these things, is going to give a final approval on a consent calendar for the final piece of destruction, the final approval of the last piece of the proposed new mural, and set the stage for destruction next month. Thanks.
Thank you. Is there anyone here to offer evidence in support of the complainant? Seeing none, the respondent, Ms. Patterson, you have 5 minutes.
Thank you. I was here at the March 5th meeting to discuss this issue, and I first want to extend an apology to Mr. Warfield. I think somehow it just, and this is not a great excuse by any means, but I think somehow we missed that we had to respond to the finding, and you're right, we should have at least told you that we do not plan on providing you with the redacted information. And this is something that we have discussed. I personally and other members of the Arts Commission have discussed at length with our city attorney. For us, the issue is that it was not clear to us that the individuals who filled out the card would be waiving their constitutional rights of privacy by participating in the commission meeting by filling out a card. There was no disclaimer on those cards, so it is presumptuous to think that they were aware of it. And while filling out the card was always optional, some may have filled out the card and included their personal information as a means to legitimize their testimony in order to, in the event that a government agency or someone on staff wanted to notify them about a particular issue, not necessarily for distribution to the general public. And as I stated at the last Sunshine hearing, we have since made changes to our card so that it does not include a space for one's address, and I have some samples here which you're welcome to look at. Additionally, if Mr. Warfield is curious about what transpired during the meeting, he is welcome to request a recording or view the minutes, which includes summaries of public testimony. And certainly, Mr. Warfield, if you do want to connect with individuals who share your passion for your particular cause, then you can also make contact with them at the meeting, personal contact with them. And it is our understanding that the Sunshine Task Force does not preempt the highest law of the state. And so I think that this perhaps is an issue that should be discussed with our city attorney, but at this point we have no intention of acquiescing to this request for the release of personal information found on those cards. In addition, Mr. Warfield did file a complaint against me for redacting the personal email addresses of emails that were sent from individuals to our staff, not to the commission, on both for and against his particular issue. And again, based on the advice of the city attorney, we redacted the personal email addresses, not work email address or work addresses or work telephone numbers, but personal email addresses, again, because it is our understanding that or our belief, rather, that the individuals who do email us directly, or as I mentioned before, who filled out those cards, were not aware that they were waiving their constitutional rights. So that's all I have to say. Thank you.
Thank you.
Facts and
Members?
Facts and evidence.
Oh, facts and evidence in support of the respondent? Seeing none. Members? Member Wolf?
Ms. Patterson, it'd be good if you sit in the front and you don't have to. We'll be quick. Try to be quick about it. If I were to find a section of state law, would that satisfy you?
I'm sorry?
If I were to find the section of state law under the Brown Act or under the California Public Records Act that you must produce those documents with that information, would that satisfy you? Because the Sunshine Ordinance doesn't stand by itself. It's an extension of state law.
I think that I would have to discuss the matter with the city attorney. Again, we're citing the Constitution of California.
This is not about the Constitution of California, because the California Public Records Act and the Brown Act are about what happens in open meetings and about public documents that must be available. And it's very specific as to what can be redacted and what cannot be redacted.
Well, again, it's not for me to say. It's an issue with, again, we are acting under the advice of the city attorney, and I understand your question, but I do not feel comfortable telling you today whether I'm comfortable with it or not. Personally, I'm very uncomfortable with the idea of me, if I, as a citizen, participated in a public meeting and, perhaps was unaware what my rights were at this meeting, or unaware, what was going to be made public, which many of the public, I believe, are in that same position, and that my personal information went to Mr. Warfield, I would be very upset.
Okay, so did your legal counsel for the commission advise you as to what section of the Sunshine Ordinance allows you to make that redaction? It's your responsibility, being here in compliance, to bring that information. Otherwise, none of this matters.
So you're saying that I should be aware of the particular section under the Brown Act that dictates what is to be redacted and what is not to be redacted?
If you are redacting, you must state the statute of which that information can be redacted. Now, I hear you presented the document, but you redacted it, so that was okay.
And we cited the
That's
Constitution.
okay.
Yeah, we cited the California
You
Constitution.
can't just cite the entire Constitution. It doesn't work that way. You have to cite the statute. You have to
Article 1, Section 1 of the California Constitution.
Well, that would be incorrect.
Okay, well then, again, this is sort of beyond me, as I'm
I
the
understand.
messenger.
And that's the problem. And so under 60, and by the order, if you look at the decision, the order of determination, the commission was found in violation of 6721E for failure to appear at the task force. And now that you're here, 6721E also says that it must be somebody that has some knowledge about what the compliance should or should not be. So as a messenger, it doesn't really help, because I could ask all kinds of questions. You're going to say, well, I don't know. I'd have to go back. That's not appropriate. That's why we've taken the time out to have these hearings, so we can get the appropriate information from the right people.
Well, I mean, I consulted with the city attorney, and this is the message, and so I will note that, and I will certainly bring it back to the office, and say that in the future, we need to cite the statute, and I'll discuss that with the city attorney as well. I don't know what else to say.
Okay, thank you.
Yeah.
Anything further? Okay, at this point, the respondent has an additional 3 minutes to make a rebuttal. Do you have anything further to say?
Say that in good faith we will respond to Mr. Warfield, explaining our position in writing, citing any statute, what have you, to make it perfectly clear how the Arts Commission's position on this matter, and so we will do that in writing. So,
Thank you. Mr. Warfield, you have 3 minutes.
Thank you. I think that the messenger, as she calls herself, well, I do think that you've certainly touched on a problem, and that is that you don't have somebody who seems particularly knowledgeable about the ins and outs, and particularly who is in charge and why are they making the decisions that they are. That person or those folks don't seem to be here, but I do think you might ask who is giving the messenger, Ms. Patterson, instructions. I think that Ms. Patterson gave it away when she said, folks who give their information by email, or presumably speaker cards, might be, I don't know the exact words she used, but it might be something that the staff of the Arts Commission might want to follow up with them on. And that's the key. They want to be able to have access to the information of contacting the folks who express themselves to them so that they can give information that they want to give, but they don't want us to have the same privilege because they know that we have done our homework, we have information that might be very interesting. She said she would be very upset if Mr. Warfield got contact information. Well, you know what? I believe that in terms of public comment, I think every single member of the public who wrote to the Arts Commission would be very happy to hear from Library Users Association because those were people who were saying, please keep the mural. Please don't destroy the mural. What she says is patent nonsense with respect to those people. In any case, agree or disagree, their purpose is that they may be able to get in touch, but that I can't, and library users can't, and anybody else that they haven't vetted can't. That's at bottom what it is. So I think that they're in flagrant violation. It took a month to get the order of determination to them, which is why we're here, presumably because they weren't able to act just on your actions at the March meeting. But they don't need to send a letter. They don't need to answer you. They don't need to answer Library Users Association. They just simply do nothing and then offer an apology, which is nice. But when there's no intention to comply, I don't think it's an accident that they haven't said anything. And their claims of contact with the city attorney have absolutely no backup, certainly not in writing, none whatsoever. Let them show what the city attorney advised. Thank you.
Can I clarify something? Is that possible, or do I wait till public comment?
Well, you can't, go, right?
That's a great question.
Yeah.
I just want to be clear because you sort of misconstrued what I said. What I said is that it's not that we are withholding information because we just want to reach out to people who've given our information, but you know, these people are providing their information to either legitimize their testimony or in the event that a staff member wants to get in touch with them. So it's not that so his logic was a little bit reverse on what I said, and I just want to clarify that that's absolutely what I did not mean what he said. And so I just wanted to make that clear. Thanks.
Thank you. At this point, do we have a motion? Member Dean?
I move to refer this matter back to the full task force with a recommendation that this be referred to the Ethics Commission for willful violation. The order of determination was issued on April 5th. The respondent had 5 days to comply. It is more than a month after that. The respondent has still not complied.
Second.
Okay.
Second.
Is there public comment on the motion?
Members of the committee, Ray Hartz, Director, San Francisco Open Government. I think that one of the things that you need to do is have the EOT reach out to the Arts Commission because they are just basically totally illiterate as far as the Sunshine Ordinance and the Brown Act. I don't know who there is required to sign the annual Sunshine Declaration and take the training, but in their minutes, in their meetings, they are consistently breaking rules. They didn't record meetings for a long time, and Mr. Warfield has brought a lot of these cases before you, and they basically haven't shown any real attempt to learn what the real rules are. And this presentation today, and I'm, again, not, Ms. Patterson is kind of caught between the rock and the hard place here, but it's kind of similar to the situation I mentioned earlier about the 150-word summaries. The city attorney issues a memorandum. It is not a legal opinion, but simply a statement saying, go by what the good government guide says. And you say, well, wait a minute, this is not a legal opinion, and you're saying this is a legal opinion, and it's not. And again, as Mr. Warfield says, she is referring and saying, well, we talked to the city attorney, and the city attorney told us this. Maybe the city attorney did tell them this, but it's nothing they're going to put down in writing because they know legally it has no validity at all. I think you're making the right decision. They were ordered to give this information. Their belief that members of the public don't want it released is just that. It's pure made up. Very honestly, I've also watched them at their meetings. They put out the cards, and if somebody didn't fill out a card, they will ask them, did you fill out a card? And the person then shuffles around and fills out a card, and they never at any point tell them, you don't have to fill out the card. So there are a lot of things, and Mr. Wolf was at one of the meetings where they started shifting around the leadership of the chair, and it was just like every one of the subcommittees was taking the chair without any sort of a motion, so you didn't know who the hell was in charge. And they were in such an automatic method that they basically didn't even ask for public comment. They simply went on to the next item until somebody says, wait a minute, you didn't take public comment. And I said, oh. And they went back to public comment and then proceeded to do the same thing 3 times in a row. So they really need to get the message clear. They have a new Director of Cultural Affairs, Mr. DeCaney. He needs to be aware that they have requirements under the ordinance, and whoever it is that is signing those sunshine declarations needs to be addressed. In fact, I think I'm going to put in a request to the Ethics Commission and find out who from the Arts Commission has signed those and has gone through the training, because whatever they say they did, it doesn't show.
Thank you. Anything further?
Oh, I don't think there's any more public comment.
No, right, no.
So I just wanted to add that under the California Government Code, which is called the Ralph M. Brown Open Meetings Act, under Section 54.953.3, it states, and I'll only read the first sentence, a member of the public shall not be required as a condition to attendance of a meeting of a legislative body of a local agency to register his or her name, to provide other information, to complete a questionnaire, or otherwise to fulfill any condition precedent to his or her attendance. And just the last sentence, if an attendance list, register, questionnaire, or other similar document, like a speaker card, is posted at or near the entrance of the room where the meeting is to be held, or circulated to the persons present during the meeting, it shall state clearly that the signing, registering, or completion of the document is voluntary, and that all persons may attend the meeting regardless of whether a person signs, registers, or completes the document. That is why the Board of Supervisors, during public comment, they read all the speaker cards first, because then you get yourself in an order. I want to be first. We'll put in a speaker card and we'll give you a preference. Otherwise, you got to wait to the end, and that's when they'll add. Is there anybody who didn't fill out a speaker card who wishes to speak on this matter? Because there's no requirement. You can speak anonymously. So any documents that are created in a public meeting are public, all of it. So if you put your address down, it's public. If you don't put your address down, then it doesn't appear. And that's the thrust of the law, state law. It's not just the Sunshine Ordinance. And we have the thrust of referring and actually overseeing the compliance of state law. And so that's where this comes from. It's under Section 1, Chapter 1 of the Constitution. So it's inclusive. And these are all the laws that are contained are specific, making exceptions and or not exceptions and going further, or making clear clarifications. So I just wanted to put that out to you. It's Section 54.953.3, and I would suggest that you contain that in your agenda like we do, we have a lot of information at the end of the agenda that actually takes up an additional two pages. You can add, as your agenda should, somewhere in there saying that there's no requirement to fill out a speaker card to speak. You just have to wait to the end. Okay. But you should also state that any information you put on the speaker card is public information. Okay. And when we reconvene as a task force, I'm sure we'll get some legal counsel to pick out the exact section on that. We've done this before.
Okay, fine. Member Nee?
I'm sorry Ms. Patterson is leaving because I have some things to say that I think she would find relevant, but listen to the recording later. First of all, Ms. Patterson said that their action, or in this case non-action, was based on advice from the city attorney. Our order of determination also is based on legal advice. It includes an opinion from an attorney who is a voting member of the task force and is a practicing attorney specializing in sunshine law. That should carry at least equal weight with anything that the city attorney says. Second thing, the task force has found in the past that unless a member of the public specifically requests that information he or she provides be withheld, then that is assumed to be disclosable public record. And if a commission or any other body is looking to protect personal information, then it is up to that body to proactively say to a member of the public, whether it be verbally or on a speaker card or in an agenda, any information you provide to us is disclosable public record unless withholding of the information is specifically requested by the person providing that information. So there is, the task force has found a presumption here that the information provided by members of the public is disclosable unless otherwise requested. And I see no reason to change that now. We know we have established our own precedent here. I personally think it's a good precedent. You know, I like continuing that precedent.
Thank you. Ms. Osprey, would you call the roll, please?
Member Nee?
Aye.
Member Wolf?
I just want clarification on the recommendation back to the task force. It's just that we continue to find them in violation.
No, the recommendation is to refer to the task force with a finding of willful violation for not complying with the order of determination.
And is there a referral?
And recommended referral to the Ethics Commission for willful violation.
Okay, very good. Aye.
Okay. Chair Johnson?
Chair Washburn.
I'm sorry, Chair Washburn. I'm looking,
Aye.
sorry. There are 3 ayes.
All right. Ms. Osprey, would you call item number 12, please?
Item number 12, Administrator's Report. I handed out the Administrator's Report. There are copies up front for the public. There's only been one new complaint since the report submitted to the full task force on May, and a new complaint was submitted by the San Francisco Preservation against Supervisor Weiner. Other than that, through April 27th through May 10th, the task force office has responded to approximately 77 calls, emails, and office visits from persons requesting information regarding Sunshine Ordinance or to mediate requests for records.
Thank you. Members? Is there any public comment on the administrator's report?
Yes, Peter Warfield, Library Users Association. These reports lack basic information about what the issue is. And I've said this before to the full task force. This is a step down. This is a degradation of this report. Complaint 412-2011, TF 421-2011, EOT 69-2011, comma, concluded. What was that one about? You used to have a log, a complaint log, that was actually understandable by an ordinary human being who didn't have a whole lot of access to, well, I'm not even sure what. It used to be understandable, as with your agenda items, which are reasonably understandable. There's no reason why this report should be acceptable in any way without at least the information that is required by the Sunshine Ordinance for an agenda item, which is that an ordinary person can understand whether their interest is affected and, in plain English, says what the issue is and what it's about. I'll just read from the end of the list, 12/20/2011, Ray Hartz versus Luis Herrera Public Library, proven as received to TF 3712 meeting, CAC 41712, TF 4412. Member Nee, seconded by Member Wolf, made a motion to table the item upholding the original order of determination. What was that about? I have no clue. I know that I myself have had difficulty differentiating just by number, as an example, between complaints without then having to refer to something else. It's especially confusing when there are multiple complaints by the same party against the same other party. And I'm not even reading from Library Users Association, but let's just look at number 1014-2011 Library Users versus Arts Commission, TF 121411, TF 4412, reconsideration, TF 4412, Member Johnson, seconded by Member Nee, moved to rehear the complaint to May 2, 2012. What was that complaint about? And why shouldn't this log show what it was about as it used to? For the Sunshine Task Force to go forward and accept this kind of a report, I think, is appalling, and I think it should not be done. It should be insisted. You should insist that it be understandable by ordinary folks. Thank you.
Member Wolf?
I have to disagree with the public commenter. I mean, there's a reference to case number and a date. You can refer back to the entire case and all the entire documents. It's all there. There's no need to have a tremendous amount of repetition or duplication or added or trees being cut down to provide so many additional pages for so much more information. If a person is really interested in the log of what's going on, it's not the administrator's just showing her time. That's all on the cases that she had worked on, or he or she at the time. Most of what you see here is not from the current administrator. It's from the previous administrator. And I don't remember, since going back to 2005, that it's been any different than this. So I really don't have any reference to what the speaker was talking about with regards to that it used to be something else. I don't find this very hard to follow. I think a court of law would pretty much do the same thing as far as the staff reporting time of what they worked on, as would any attorney. This is the same format as attorney would give their boss in order to get a paycheck at the end of the week, 2 weeks, or the month. So I don't see that there's any problem with the way the current log is set. I don't think there's any reflection on the current administrator with regards to that. If there needed to be a change that would come from the chair as a directive, because it's more or less a report to the task force. So if the task force wanted something different, that's fine, but it should not reflect the administrator. The administrator's just doing his or her job as directed. So I don't see there's any problem with this. I think it's fine the way it is. All I would say is Ms. Osbury, if you would like some help in how to create the lines, I can certainly show you how to do that. Okay? Thank you.
See, do we need a motion to accept the administrator's report?
I don't think we ever do.
I don't think we ever do, although it says
Part of the record.
action here.
We can. In the past when we used to take committee reports, we used to approve them into the record. But that would create a new. If you want to create a new precedent, you can.
No, I'm not interested in
Okay.
doing that. Ms. Osbury, would you call item number 13, please?
Item number 13, announcements, comments, questions, and future agenda items.
I have a few. Oh, go ahead. Okay.
Member Nee?
Yes. Back for a minute to the question of the amendments. I suppose this is something I should say to the full task force as well. So far, I've been kind of a point person in dealing with certain members of the Board of Supervisors on this, on the amendments package. So far, I've spoken with only one, Supervisor Campos, who seems receptive, but he urges that we also contact Supervisors Avalos and Marr. I have already in the past contacted Supervisor Avalos and have received no response. I have not had a chance to approach Supervisor Marr about this. Since I am going off the task force, the task force may want to appoint a new point person on this. Certainly that would be up to them. I am happy to continue pursuing this as a member of the public, as a longtime activist on Sunshine, and work with the task force on trying to get this on the November ballot. So where the task force wants to go from here, I guess that'll be up to the new members to decide.
Well, I, for one, would be very happy to have you continue being the point person, and you'll have more time to do it.
Theoretically.
Member Wolf?
Yeah, if there was nobody who's going to step up, I would also, considering relationships and, with certain supervisors. So I think it would, I'd be happy to join you if you can't make it to it.
Well, it depends. If the task force wants to appoint me as kind of as still representing the task force in this, certainly if that can be legally done and then the task force wants to do that, I'm happy to do it. If the task force decides to appoint a different point person, I'm certainly happy to work with that point person and see if we can pursue this together.
We can make you an agent of the task force
and I would
with a badge.
Yeah.
And I would sign a contract, of course.
Subject to the sunshine
Subject to
ordinance.
sunshine, right.
So I have a few items.
Okay. Member Wolf?
One is that I have a list of items for a Rules Committee meeting, which will have to wait until after the new members come on. But I wanted to take into account Mr. Warfield's suggestion of having an area where there are some standard opinions or rulings that we have made so that people understand, that are, kind of global and comprehensive with regards to certain things like speaker cards, that kind of thing.
The minutes.
Right, the minutes, that kind of
150
stuff.
words.
I wanted to say something during the public comment period, but we wanted to move the agenda forward. So I'll say them now. With regards to Mr. Garza's comments, I would say to him, if he's listening to the tape, that he should look at the amendments. That all his concerns and angst about what the Sunshine Task Force can or cannot do are answered in the amendments, hoping that it gets passed. They'll be created as a commission with some enforcement power and some ability to do to subpoena and whatnot. So, I think that his call for all of us to step down to try and, make an activist stand, in other venues, I would say, yeah, that might be good. Like if all students were to leave campus, on strike, that kind of thing, it doesn't work for this body. The fact that we must stay here and we must maintain holding the torch so that we can get the amendments passed so that it can progress and move on in a more productive and justified way. And, the whole thing about the HIPAA thing, it wouldn't have come about unless he keeps accusing me of not doing anything. So I just wanted to respond to him by saying, I'm the one that brought it up. I'm the one that kind of pushed the item forward to this body, to get it done. Unfortunately, I got very, very ill, and it took me 2.5 months to recover. I couldn't do any work. I was on a leave of absence. So, if I'm not just trying to put myself up, I'm just saying any member of the task force could have done that, and he should recognize that. He may not like how fast we do things, but eventually, I'm committed to make sure that it happens one way or another. And I wanted to just respond to Mr. Warfield with regards to the Arts Commission, the committee on the mural. I'm wondering if you may have any friends that might sever that item out of the consent calendar. And if they can, then at least you'll have some debate separately. And it could be possible if you nudge them enough. So with that, that's all the comment I have. Thank you.
Thank you.
Oh, I do have one more. I'm sorry. And I'll bring this up with Ms. Osbury separately. All the cases and reports of votes from February 10th until the meeting that I came back to the task force should be noted as medical leave and not as absent, because we amended our bylaws that if there are more than 2 absences, I think it's more than 2 absences, that a warning letter would go out. The administrator would have the power to send, or the authority to send notices up to the Board of Supervisors. So I want to make sure that for the period of time that I was on medical leave, that all the tallies of votes do not mark me as absent, but as excused. Okay? So that I don't get dinged by our own bylaws. Thank you.
I think we had you covered, but you want to make sure.
Yeah, well, I noticed it in I think it was Mr. Hartz's case, the order of determination has me marked as absent.
Oh, okay.
So that's what triggered it for me when I saw it. So I'll go over that with you. I just want to make sure I get on just some record, and then I'll bring it up at the task force meeting if there needs to be some decision at the full task force meeting about that. That's it. That's all I have.
At this time, I'll entertain a motion to adjourn.
Comment on, no, this is not public comment. Public comment on the item? Okay. We're not taking any action, but okay. Whatever you want.
On announcements and comments and.
Yes, since the discussion brought up the amendments and trying to get it on the November ballot, I still am very adamant about the fact that going backwards on the effort that I have made to get the 150-word summaries into the minutes, because the Ethics Commission, in their reply to the complaint against them, was to put your amendments forward and say, look, you're even recommending attaching them instead of including them. And I really do think that they gave me 134 pages, and a lot of it was copies of the proposed changes to this ordinance. And multiple ones of those were that it was okay to attach them rather than include them in the minutes. And I think allowing that to go forward, if it hasn't been changed, maybe it's been changed, but if allowing it to go forward would actually be a step backwards and would actually restrict the rights. I really do emphatically feel that the Sunshine Ordinance provides one additional layer of protection, and it says that I, as a member of the public, if I feel my comments are being unfairly placed in a government publication, I can submit my own summary to ensure that what I really intend to say and what I really did say make it into the official record, and not that they're attached. Very honestly, I've been through this permutation so many times with different bodies like the Ethics Commission and the Library Commission and so forth. They all want to do it a different way, but it's all done, in my perspective, or from my perspective, with the intention of marginalizing and minimizing public comment, and in particular, the dissenting public opinion. I really do think that they have used it as a method to just basically, we can't stop you from saying these things we don't want you to say, but we can make sure it does not get into the official record. And what they did for example, on the Ethics Commission website was put it on the website, but you had to know to click a link for it to come up. And if you printed out a copy, it didn't print. Now, they've changed that, but again, there's all these different permutations. I think the importance of that 150-word summary being in the minutes, in the place where the comments were made, is, I think, just a protection of First Amendment rights.
Thank you.
Peter Warfield, I would certainly agree with the previous speaker, and I guess I'm interested in what are the amendments that, at this point, there have been so many rounds of amendments going up and down and back and forth and forwards and backwards and then failing to move forward to the Board of Supervisors. I don't know any longer, and I'd be very interested to see what the amendments are, if any, that are currently under discussion for supervisors to go forward with them. I would certainly agree with the previous speaker that in the minutes means in the minutes, as you have found, and that's very important, because if not, you can see from the library itself all the games and all the tricks that are done to marginalize and even to make people unaware of what's going on. I mean, when I start reading boilerplate about wood from Burma and people wearing scent, I generally think I'm in a boilerplate section, and I'm not going to read any further. I've seen it. Maybe I have read it at some point. Once in a while, I notice that the Sunshine Task Force administrator has changed and that the boilerplate has not. With respect to future agenda items, I would certainly recommend that you observe and have a discussion about your own procedures and holes and flaws with respect to following them and with respect to what they are. As an example, I've repeatedly asked to be informed when the deadline is for me to provide additional information on the agenda so that you can get with your packet information such as, I haven't gotten anything from the Arts Commission with respect to speaker cards. But it isn't just a matter of getting it to the members. That's important. But it's making it clear to the public, making it known to the public that nothing has happened, letting the public hear what the complainant has said. So that, I believe, is a flaw in the procedures. I did speak with Rick Caldera about the procedures, and I saw all kinds of deadlines for the administrator with respect to how to put forward, when to give it to the webmaster, and so on. But there was no deadline, and there was no mention in what I saw. When do you send something to the public? How much time do you give the public to provide something? In addition, when I say following the procedures, it really pains me that when I am supposed to have, under your procedures, the last word, that you allow a proven violator to come up here and make some kind of a correction or get a last word in about something that I have said that she supposedly thinks is correct. I think that's inappropriate.
Mr. Warfield, this is not like general public comment where It's
something
not a
I
second
think
bite of the apple for general public comment.
I'm suggesting that you look into, for a future agenda item, how carefully you follow the procedures and also how complete the procedures are.
If you'd like to put them in writing, me as the chair of the task force, I'll be happy to look at them,
Look at what?
what you're suggesting.
Well, I'm giving it orally. Thanks.
Okay,
Okay, at this time, I'd like to entertain a motion to adjourn.
so moved.
Second.